Welcome to In and Around War, a podcast of the Geneva Academy of International Humanitarian Law and Human Rights on contemporary issues related to wars.
Hello everyone and welcome to another episode of In and Around Wars, a podcast series organized by the Geneva Academy of International Humanitarian Law and Human Rights, which focus on contemporary legal issues related to armed conflict. I am Eugénie Duss and I am a research fellow at the Geneva Academy.
And hello from me, I am Francesco Romani and I'm also a research fellow at the Geneva Academy. Thank you for having me here.
Thank you. Today we will be building on the lively and rich discussion that we held a few months ago during a Geneva Academy talk, which we dealt with the intersection of armed conflict and food insecurity through the lens of international humanitarian law and human rights. This discussion was held in conjunction of the launch of the first sport report under the Geneva Academy IHL in Focus project. This sport report explores food insecurity in armed conflict and the use of siege-like tactics and is available online on the Geneva Academy website.
We thought we could start this podcast by reading a passage from the spot report, which reads as follows, I quote, "Over the past year, populations trapped in areas affected by conflict, such as Mali, Sudan, South Sudan, and the Gaza Strip, have faced emergency levels of acute food insecurity, with high risks of famine looming over, if not already existing, in certain areas. This has occurred despite the existence of international humanitarian law rules aimed at preventing and mitigating the impact of armed conflict and military operations on civilians. In particular, those prohibiting the targeting of objects indispensable to the survival of the civilian population, the use of starvation of civilians as a method of warfare, and the requirement to allow and facilitate the rapid and unimpeded passage of relief consignments, equipment, and personnel to civilians in need. Concerns about the impact on civilians of lack of compliance with international humanitarian law in this context were underscored by the United Nations Security Council in Resolution 2417 of 2018, condemning the starving of civilians as a method of warfare, the unlawful denial of humanitarian access, and depriving civilians of objects indispensable to their survival." End of quote. As you're all well aware, the relationship between armed conflict and food insecurity has been a long-lasting feature of international relations. This being said, there are probably a couple of aspects of this vicious cycle that characterize the modern world. That is, on the one hand, the magnitude of the phenomenon, and on the other, the severity of this phenomenon. We see nowadays in armed conflicts that the scale of food insecurity is quite unprecedented, and the gravity of the situations that we're witnessing nowadays is also quite a new phenomenon. This is the reason why we have decided to dedicate a podcast to this topic, to try and understand a little bit what are the IHL rules that, if complied with, would reduce the risks for severe food insecurity for civilian population. And to do that, we're very lucky today to have as a guest Yousuf Syed Khan, who is a non-resident senior fellow at the Atlantic Council, a person who has served in 4 commissions of inquiry and investigative bodies established by the Human Rights Council, and therefore has a long experience in researching and working on these issues. Yousuf, thank you very much for joining us today, and welcome.
Thanks for having me.
I think we could start a discussion by trying expanding a little bit on the rules that we also made reference to in the quote from the spot report. And probably as we know, the general rules on the conduct of hostilities would continue applying and address questions related to food insecurity. But probably the best way to start a discussion is by looking at the prohibition of starvation of civilians as a method of warfare, which is a key IHL rule that can address these aspects. Yousuf, would you please share with us a little bit what are the main aspects of this rule and what are the main questions that arise in relation to its interpretation and application?
Sure. So as a baseline, we can look at ICRC Customary Rule 53, which states that the use of starvation of the civilian population as a method of warfare is prohibited. The reason I start with ICRC Rule 53 is because, as we know, the war crime of starvation as a method of warfare did not apply to non-international armed conflicts until Switzerland proposed an amendment in 2017. So a lot of my work, particularly on Syria, which preceded 2017, where starvation was occurring in the context of a non-international armed conflict, was based on this customary prohibition. According to ICRC Rule 156, which encompasses the definition of war crimes or serious violations of international humanitarian law, Rule 53, its language applies to both non-international and international armed conflicts. Moving on, we can discuss the protection of objects indispensable to the survival of the civilian population, which is stated in Additional Protocol 1, Article 54. Article 54.1 states that the starvation of civilians as a method of warfare is prohibited, and 54.2 goes on to describe a non-exhaustive list of foodstuffs, agricultural areas for the production of foodstuffs, crops, livestock, drinking water installations, and other items, again, that are emblematic, although non-exhaustive, of which is prohibited to attack, destroy, remove, or render useless. Though starvation as a method of warfare has been interpreted under the commentary of 1987 to Additional Protocol 1 as a weapon to annihilate or weaken the population, it's important to underscore that it is a crime of intent and not of result. There's no requirement that anyone should have died from starvation or that any military advantage was gained. Rather, the war crime itself only involves the deprivation of objects indispensable to survival and requires two elements of intent: the intent to deprive civilians of these objects and the intent to starve civilians as a method of warfare. Under the Rome Statute of the International Criminal Court, similarly, intentionally using starvation of civilians as a method of warfare by depriving them of these indispensable objects, including by willfully impeding relief supplies, is a war crime. So the critical question, I think, that arises when you're looking at starvation as a method of warfare versus incidental hunger is, what does intentionally mean? In my work, both the intent to deprive and the intent to starve has been proven through indirect or oblique intent. That is, where the perpetrator knew or should have known that their conduct would lead to the outcome in the ordinary course of events. So where in the ordinary course of events, the deprivation of objects indispensable to survival and or the starvation of civilians is a foreseeable consequence. But I guess a similar question is, how far do we stretch that rubber band? I guess it's contextual. Depends on several factors, including the environment, what is available, what can we argue constitutes an indispensable object. It's situationally indispensable. This will be different in places that you mentioned, for example, in East Africa, when compared to the dead of winter in Mariupol, Ukraine, both places where starvation as a method of warfare has occurred.
Thank you, Yousuf. You have hinted at a number of questions that are extremely important in the interpretation of Article 54. You mentioned the question of intent under the criminal law aspects of the prohibition. There's also a similar question with regard to whether the starvation of civilians must be deliberate under the IHL prohibition, or rather if it's only a question of foreseeable consequences. Would you like to expand a little bit on that, perhaps, because it's something on which the scholarship has a lot of troubles discussing about?
Sure. In the absence, obviously, of international case law on starvation as a method of warfare, we won't have, in that sense, concretized judicial decision. However, we can look at patterns of conduct. In your report, you discuss siege-like tactics. I would say over the past decade in particular, beginning with the siege of Madaya in Syria, we began to see conduct that included not only attacks against what would very clearly be deemed objects indispensable to survival, but as well as the denial of freedom of movement, the denial of humanitarian corridors, attacking humanitarian corridors, and this notion that the population was being collectively punished. When I say this notion that the population was being collectively punished, these are findings made by the United Nations in the context of Yemen, in the context of South Sudan, in the context of Ethiopia, as well as in the context of Syria. If you look at the findings by commissions of inquiry and fact-finding missions on those four mandates. Similarly, with respect to the arrest warrants that we saw applied for in the context of Gaza, we also saw collective punishment. So in the aggregate, when you're talking about a population that is roughly in the thousands or tens of thousands, or in the case of Gaza, 2.3 million, and treating those individuals all in the same manner, it takes a manifest effort to carry out that conduct, particularly in a siege context. Then we begin to be able to tease out aggregated criminality and intent. Another thing I'd mention in the context of sieges is that besides the amount of military effort it takes to enforce the siege, is the notion that oftentimes sieges can either be porous or they can be full-on blockades.
Yeah.
With respect to porous sieges, we can look at Mariupol and this notion that individuals were able to leave. We have to also understand why that was the case. If you're going to make a finding of starvation as a method of warfare, why were Russian forces and affiliated forces, including militia groups, allowing individuals to leave? Well, one of the military logics by laying a porous siege is to be able to, as we know in the context of Russia, is to be able to filter the population for their perceived loyalties. And the same thing happened in the context of Syria, because Syria's reconciliation agreements, as they were known or referred to, modeled the Russo-Chechen conduct of filtration. And then the full circle came around in the context of filtration that we see across Ukraine. So this notion of allowing individuals to leave from besieged areas can have several sort of underlying reasons that don't take away from the notion that starvation as a method of warfare is being used. It can be used for intelligence gathering purposes. It can be used, for example, when the population, again, is going to be filtered for its perceived loyalties. And ultimately, you will always have the same outcome. So across Syria, 15 to 20 sieges across Syria, as well as in the context of Ukraine, that same outcome is displacement. And there is very clearly a starvation displacement nexus when you look over the conduct of hostilities over the past decade. I'm grateful to have my work on the starvation displacement nexus included in the report to the General Assembly by the Special Rapporteur on the Right to Food, Michael Fakhri. But it's also a phenomenon that occurs in East Africa, including in South Sudan.
Thank you very much. You're teasing out a number of aspects which really show to what extent this prohibition interacts with other prohibitions. And it's important to remember that when we talk about IHL safeguards that might be used in order to prevent food insecurity, there's a lot of interactions with other applicable rules, with specific protections that are established under IHL. And I would like perhaps to highlight the reference that you made to the issue of starvation and forced displacement, which is something that really arises also from the text of Article 54, when we see that when we talk about objects indispensable to the survival of the civilian population and the absolute prohibition that we see there, these two elements, the risk of starvation and the risk of forced displacement, are put together, which is something that is not really something that we would see, for instance, when we have a proportionality assessment. So this is I guess, an aspect that is worth teasing out. Perhaps a final question on Article 54, and one aspect that is perhaps less discussed than others, but I think it's important to highlight this reference to scorched earth policies that is included in paragraph 5 of Article 54. Could you perhaps share a little bit of what the main aspects of that rule are and what the implications might be on the conduct of hostilities?
That's right. With respect to scorched earth, under paragraph 5 of Article 54, Additional Protocol 1, party to the conflict in the defense of its own national territory against invasion may derogate from the provision of attacking objects indispensable to survival, but that would not apply to the belligerent carrying out an attack, for example, not to Russia in the context of Ukraine, but to Ukraine regarding its own national territory.
Yeah, at the beginning of this discussion, you briefly mentioned, Yousuf, the denial of humanitarian access. And I would like to focus now a bit on the obstruction of humanitarian assistance, because as we all know, parties to the conflict are obliged to allow and facilitate the rapid and unimpeded passage of humanitarian relief for civilians in need, but also for other protected persons. But this passage is subject to the consent of the concerned parties. And do you think that such consent can be withheld in contexts where there is food insecurity or even a risk of famine?
I would start perhaps with teasing out this notion of consent under Additional Protocol 1. Consent can be bifurcated into both strategic and operational tiers. So with respect to strategic consent, it's obtained at the higher, more formal levels of leadership or authority, often from the national government or top military command echelon. Perhaps even senior representatives of non-state armed groups. And then, as you noted, with respect to humanitarian aid, we know that it has to be impartial in character, but it should also be subject to the right of control of the other party. And that's where you have what can be termed operational consent. And that's about translating strategic consent into actual on-the-ground access. Now, what we know is that such consent cannot be withheld arbitrarily. The notion of the arbitrary withholding of aid is exemplified currently in the context of Gaza, where we have from, I won't call it a leaked document, but we know from senior U.S. officials, including those who have spoken to international media, that baby formula is being withheld, which obviously has a disparate impact on children. We know that Gaza was preparing for winterization and tents were being withheld, given that the metal poling in tent could be weaponized, according to Israeli authorities. And again, I think you hit the nail on the head with respect to the situational nature of objects indispensable to survival and what they mean in a particular context, as well as to the individual victims or survivors who are being, or who must benefit from that. Children obviously face compounded harms that need to be taken into account, as well as climactic factors and other factors. So I would say that it is context specific. Where there is a risk of famine, surely I would say that humanitarian corridors, which is not a given under international humanitarian law, but those should be prioritized clearly, particularly in the siege context, to remove individual civilians.
Thank you. So if I understood well, in context where there is a risk of food insecurity or famine, withholding the consent will be in some way arbitrary.
It could be, yes.
Yeah, it could be. And could you explain a bit more?
Famine is not an overnight phenomenon, particularly if you look at the IPC scale. Famine is IPC level 5. Mm-hmm. That doesn't happen overnight. So if we go back to the Rome Statute of the International Criminal Court and we say that there's a standard of foreseeability with respect to this conduct, if you are attacking, for example, situationally objects that could be deemed indispensable to civilian survival in the context where, for example, civilian population in Tigray, Ethiopia, their lives and livelihoods depend on agriculture, and that agriculture is being weaponized, if fields are being raised, if mines are being laid, there's clearly a foreseeability to that conduct. And before you reach IPC level 5, there should be an understanding that either humanitarian access should be granted in an impartial manner, or individual civilians should be able to exit an area, particularly when it's encircled through, for example, humanitarian corridors.
Thanks a lot. And I would like now to address the issue of cross-border operation, because you work on the situation in Syria, and the issue of cross-border operation has been extensively discussed in this context, especially as regard the United Nations cross-border mechanism, aid mechanism, And I would like to know your view on whether such operation can be carried out without the consent of the territorial state.
So, of course, the United Nations Security Council can override sovereignty if it deems the situation to be a threat to international peace and security. This we all know. And this has been done in situations where the denial of humanitarian aid exacerbates a crisis or indeed causes severe suffering, such as in the context of Syria. You have Security Council Resolution 2165, as well as its various extensions. So that in subsequent resolutions authorize cross-border humanitarian aid without the Syrian government's consent due to the scale and severity of the humanitarian crisis. Noticeably, that was able to be done because neighboring states would participate in this facilitation. If you look at, again, the context of Ethiopia and Tigray, you have Eritrea on the border, who was a party to the conflict at the behest of the Ethiopian government. So why a similar resolution would not be passed in this context is probably because the likelihood of that aid being facilitated was much lower, and this is potentially the result of realpolitik.
Thank you very much. And do you think that the same could be said outside the adoption of United Nations Security Council?
That member states would have an obligation to facilitate cross-border aid outside the Security Council resolution?
No, maybe more because this debate was also that some expert and NGO argue that in relation when the territorial state is denying access to humanitarian actor, if, as you mentioned, the adjacent state and the non-state armed actors that is controlling the area consent to such assistance, it should be implemented. And what are your views on that? I'm not sure I was clear, but...
No, it was quite clear. On that, I could say that certainly if you look at the Syrian context, when Bashar al-Assad was in power, there was a legitimacy, a question of legitimacy in terms of wanting all aid to be emanating from Damascus, because it gives an authoritative quality to the state. And then naturally, as we know, with the Bab al-Hawa and other crossings and the UN resolutions, aid was given to United Nations designated terrorist group at the time, Hayat Tahrir al-Sham, which raises similar questions as to the one you posed. Similarly, this is a question that would arise in the context of humanitarian aid drops. I think if we look at, for example, this notion of arbitrariness, and it can be said that aid is being withheld arbitrarily, and then we look at the Geneva Conventions and the obligations of states to ensure respect for these conventions, there may be an argument to be made that states have this obligation, but that's an interpretation. And I would leave it at that.
So, Yousuf, I will carry on the various international response that food insecurity and armed conflict have received at the international level. For instance, in its resolution 2417 from 2018 that both of you have already mentioned, the United Nations Security Council recalled that the use of starvation of civilians as a method of warfare is unlawful, and the Security Council also state that in some instances the unlawful denial of humanitarian assistance can be a threat to international peace and security. This was one international response among others. I would like now to focus on international courts, which have also grappled some of the issues that we are discussing now, and I would like to focus on the criminal ones. Under the Rome Statute, as you already mentioned, Yousuf, the starvation of civilians is a war crime in international armed conflict, but also since 2019 in non-international armed conflict, following the adoption of the amendment by the Assembly of State Parties. And on this basis, the pretrial chamber of the International Criminal Court issued arrest warrant for Benjamin Netanyahu and Yoav Gallant. According to the chamber, there were reasonable grounds to believe that they bear criminal responsibility for the war crime of starvation. And leaving aside the unlikelihood of an arrest, in your opinion, are there any particular challenges to prosecuting individuals for the war crime of starvation?
I think there's a couple things we can say here. One is with respect to the Gaza context specifically. In the initial days of the conflict, you had Defense Minister Yoav Gallant saying explicitly, there will be a total siege on Gaza imposed. No food, no water, no fuel. Everything will be closed. I mean, this type of brazen language is rarely seen. We mentioned several other sieges throughout the duration of this podcast, particularly 15 to 20 sieges across Syria, as well as sieges in Ukraine. Similarly, in the context of Tigray, where you rarely see such statements by high-level officials being made. So I think if we're going to look at the notion of intentional starvation, it may be a bit clearer in the context of when high-level government officials make such statements. That, coupled with jurisdiction, may be the basis of why we're seeing for the first time this application for arrest warrants, as well as it being granted. A second similar challenge may arise with respect to the armed group, quote-unquote, governing the territory. In the case of Gaza, you have Hamas. However, throughout Syria, you had, in eastern Ghouta, Jaish al-Islam, as well as Hayat Tahrir al-Sham, and other armed groups. If you look at, for example, the fall of Aleppo in December 2016, what you saw is reporting that numerous warehouses were found where humanitarian aid was being kept. Now, the question becomes, is that a form of misinformation or disinformation, or is that armed group, quote, governing that population distributing humanitarian aid, or is that armed group, quote, governing that population keeping the humanitarian aid for itself, or weaponizing it against its own population? And so similar arguments may arise in the Gaza context with respect to Hamas and affiliated armed groups in control of that territory as to whether or not any aid that was allowed in was being withheld from the population based on the actors on the ground. And this is something that on a case-by-case basis will always have to be teased out.
Thank you very much. I assume that in this case we are lacking of official statement that will be corroborate the possibility of the commission of war crime. I think maybe you want to jump in.
Yeah, perhaps I think it's important to continue reflecting a little bit on these type of conducts being adjudicated before tribunals at the international level. Eugénie was referring to the prosecution of these crimes at the international criminal level. I think, as you were also you were addressing briefly that in one of your previous answers, we see a concomitant trend at the international criminal, at the International Court of Justice, for instance. In the past few years, we had a number of provisional measures being taken by the International Court of Justice in the case between Armenia and Azerbaijan on the application of the International Convention on the Elimination of All Forms of Racial Discrimination. The issue there was the so-called closure of the Lakhchin corridor. And more recently, we have seen a couple of provisional measures being adopted by the International Court of Justice in relation to the so-called complete siege of the Gaza Strip in the proceedings between South Africa and Israel on the application of the Convention on the Prevention and Punishment of the Crime of Genocide in the Gaza Strip. So these are all developments that they are symptoms of a bigger trend, perhaps, of adjudicating wartime conducts before international tribunals. What's your take on this development? There's a number of issues that could be discussed there: the issue of jurisdiction, the issue of framing these conducts that are potential IHL violations in relation to other conventions. Do you think it is a positive development? Do you think it's a way that would ensure an enhanced respect for these IHL rules, or do you see any challenges in that?
I do find it very important, for example, that the notion of the weaponization of food can be linked to potential genocidal intent. That's number one. Number two, given the number of states that are affected by the certain weaponization of food, and particularly if we look at the weaponization of agriculture in the context of Ukraine, which is a major global supplier of wheat, we see that Russia's conduct along the Black Sea led to food shortages and inflation worldwide, which has reverberating impacts on some of the most destitute countries, particularly across Africa. And so sometimes, though, food insecurity is not the primary legal argument of a case, or it brings to light some of this pernicious conduct and broader weaponization. And it goes back to the fact that food insecurity is not only related to sieges or siege-like tactics. It can be weaponized in various ways, including genocide, as well as in the context of grain. So in the context of starvation as a method of warfare and the definition of civilians, as noted, millions of individuals are dependent on Ukrainian grain to meet their needs. Under Article 50 of Additional Protocol 1, the definition of individual civilians may include non-combatants outside of the territory of a conflict zone. So that could be civilians in third states. Because neutral third states were the intended recipients of Ukrainian grain that was systematically attacked by Russian forces, and indeed that grain was destined for export, those civilians in those third states may be said to have been directly and foreseeably harmed and may have recourse in that regard. This is an argument proposed solely by a scholar by the name of Tom Denenbaum, and this is a position taken by an organization called Global Rights Compliance in the context of Ukraine.
Which raises a lot of issues from a purely IHL perspective, the issue of direct and indirect effects, to what extent you could incorporate effects that need to be foreseeable but might be a little too remote in the proportionality calculation. And it also brings into the question the issue of the field of application of these IHL treaties, which are normally focusing on the populations that are mostly affected by conflict. Do you think that these legal challenges within IHL should not act as an hindrance to the extension of these inclusion of damages to potentially third-party states, or do you think that would work too much as a resistance?
In the context of the Black Sea Grain Initiative, which was agreed to under the auspices of the United Nations, and Russia's conduct along the Black Sea, this is systematic conduct, and this was carried out alongside a broader weaponization of agriculture, whereby Russian forces rebuilt the rail infrastructure and the road infrastructure in areas that it occupied in order to control the export of grain back to Russia. And we're talking grain in the amounts of billions of US dollars. So to say that this conduct might be too tangential to an overall warring strategy, I would have to disagree with. However, are the rules prepared, as you mentioned, to be able to address this conduct? And that would be a separate question.
Because I think, playing the devil's advocate a little bit in there, we could say IHL is already so much under strain these days. It is so contested. There are so many challenges to the application of IHL rules. Even those that are the least contested, sometimes there are troubles seeing them complied with. So is it good to rely on the IHL arguments to try and broaden the protection also for cross-border effects of starvation or even longer-term implications of starvation? Or do you see any other potential legal regimes that could take care of them and leave IHL more to the conflict situations without broadening its field of application?
So there are perhaps two answers. One, I would say that the notion of addressing pattern conduct across several continents over the past decade entails, I think, as the Graduate Institute and Geneva Academy are doing, is taking a closer look as to why siege-like tactics have been so perversely successful, and the fact that food insecurity is not the result of incidental harm. A second would be to take a closer look at Professor Andrew Clapham's argument that by its very nature, siege-like conduct violates human rights. And there you certainly have enough of an argument and an understanding that perhaps you don't need to focus on the fact that sieges are foreseeable under or foreseen under the Geneva Conventions, and they may be laid. If by its very nature this conduct is disproportionately or disproportionately impacting civilians or targeting civilians, then per se it's a violation of several international human rights norms.
So thank you very much. Before ending this fascinating discussion where we address the legal but also practical challenges that arise from food insecurity and armed conflict, I would like to ask you, Yousuf, if you could please select 3 adjectives to describe the current legal protection from food insecurity in armed conflict.
I would say semi-adequate, developing, and needed.
Thank you very
Which
much.
points both to the critical aspect, but also to the reasons for optimism that we might already be witnessing in the current developments.
Yeah, I think it's a good summary of the discussion that we just have now, and which I would like to carry on, but we need to end it now. And this brings us to the end of another episode of In and Around Wars. I would like to thank you very much, both of you, Yousuf and Francesco, for this enlightening chat. And also I would like to thank our listener for tuning in.
Thank you very much to Yousuf and to all the listeners, and to Eugénie for having us.
Thanks for having me.
You've been listening to In and Around Wars, a podcast of the Geneva Academy of International Humanitarian Law and Human Rights. If you've enjoyed this episode, don't forget to subscribe and stay tuned for more inspiring conversations. You can also check the Geneva Academy's website, geneva-academy.ch, to find more resources and upcoming events on contemporary issues of international humanitarian law and policy.